I'm Graham Broadbent. I lecture in law at Kingston University, and this lecture is part of a series on the English legal system. In this lecture, I'll be talking about the sources of law and also about the court system. As we've seen in any rule-based system, we need to know what the relationship between the various rules is, and we need to know where the rules come from. We also need to have a mechanism for adjudicating when disputes arise in respect of rules. And so, with law, what we need is a set of clearly defined sources. We need to know where we get the law from. And we need to be able to recognise that what we're dealing with is law, as opposed to other things which are not law. Also, we need to know what happens if a legal rule is the subject of a dispute. And for that purpose, we have the courts. So this lecture basically falls into two halves. Firstly, we'll look at the sources of law, and secondly, we'll look at the court system. So if we turn first then to the sources of law. Now, as far as the law is concerned, it's fairly straightforward. We have a finite number of sources from which we get legal rules. We know what those sources are, and we know the format in which the rules come out. So we can differentiate clearly between things which are law and things which are not law. The implication of something being a legal rule, of course, is that it brings with it the whole of the legal system. It brings that particular rule into the structures of the courts, of the roles of particular individuals, and in terms of the way in which the rules are administered. We also need to have rules about how we deal with rules. The law is a very hierarchical system, and this is true with regard to the sources of law. We need to know what happens if a rule from two different sources comes into conflict with another rule. Fortunately, there are rules which determine how we resolve those sorts of conflicts. So we've got a finite number of sources from which we get the law, and they are in a hierarchical system. So if we start at the top, we have the laws of the European Union. Britain's membership of the European Union was brought about in legal terms by the coming into force of the European Communities Act 1972 on the 1st of January 1973. There are implications of the UK's membership of the European Union in terms of having to particularly agree to the principle of community sovereignty. This is the idea that European law is uniformly applied across the member states, and thus in the event of a conflict between a rule of European law and a rule of law in one of the member states, the European law prevails. That's a necessary principle to make the community work, to make it work across the Union in terms of having a uniform application of European law. That principle is encapsulated in Section 2 of the European Communities Act, which provides, amongst other things, that every act passed or to be passed is to be read in the light of particularly the principle of the sovereignty of the European Union. So it follows from that that English domestic law has to give way to rules of European law in the event of a conflict. So European Union law then is the most authoritative source in those areas, of course, in which the European Union operates. As essentially a commercial and economic union, it has a limited impact on English law. It only really operates in those areas of economic, commercial activity that we'd expect to be governed by a community with those sorts of interests. However, the European Union is increasingly developing a social agenda, and we can perhaps expect that there will be further expansion of the influence of the European Union in years to come. If we turn then to domestic law, the highest authority is accorded to Acts of Parliament. These take precedence over other forms of law within the United Kingdom. An Act of Parliament is something that comes out of Parliament in a particular form, and we'll be looking in a future lecture at the way in which legislation is passed and how it's interpreted. An important feature of legislation is the increasing use of delegated legislation. This is sometimes called secondary legislation and is generally made under the authority of an Act of Parliament. What increasingly happens in modern Acts of Parliament is that Parliament creates a framework and leaves the detail to be filled out by secondary legislation. Secondary legislation therefore deals with the detail. It also enables legislation to be amended more easily, enabling it to keep up to date with changing demands or circumstances, and enabling parliamentary time to be saved by not requiring Parliament to scrutinise every single detail that may be relevant to a piece of legislation. So Acts of Parliament are a really important source of law in the domestic sphere. In modern times, the Acts of Parliament have overtaken the common law as the predominant source of domestic law. The third source of law is, in one sense, not a source of law, because it involves the principles of equity. Equity is something which is unique to English law and derived from a system of dealing with the defects of the common law in the 14th and 15th centuries. The common law by this time had become very rigid, and there were various things that it simply couldn't do. If, for example, somebody gave property to another person, asking them to look after it for the benefit of a third party, the common law simply wouldn't recognise that obligation. It would regard the transfer of property as being a direct and unqualified one. So what happened was that people petitioned the king to try and get a remedy for this particular injustice. The king delegated the remedying of these sorts of grievances to the Lord Chancellor, who developed principles essentially based on conscience. Lord Chancellors in that period were largely clerics, and they were governed more by moral principles than anything else. And so what they did was to, in that particular example, enforce the obligation with which the property had been given. So equity gradually grew up as a system designed to remedy defects. But in doing so, it became quite creative. It created new forms of property holding, and the device I've described became what we now know as the trust. It also developed new remedies. The common law couldn't do anything except provide compensation for loss. What equity could do was provide remedies which forced a person to do something or stopped a person doing something. The injunction, which is a very common remedy these days, developed in this way. As it was operating essentially as a matter of conscience, equity developed on a fairly ad hoc basis. The Lord Chancellor would simply make decisions on the basis of what he thought was correct in the particular situation. However, as the system became gradually more formalised, some sort of system of precedent began to grow up. But perhaps the most significant development was that inevitably the principles of equity came into conflict with the common law. In a case in 1615, the Earl of Oxford's case, it was ruled that where there was a conflict between equity and the common law, equity would prevail. That rule is now enshrined in Section 49 of the Supreme Court Act 1981. And in the reorganisation of the courts in 1873-5, under the Judicature Acts, the principles of equity were merged with the principles of common law in the unified court system. What happened was not that the principles were joined together, but rather that the system for administering them was fused. The final source of law is the common law. This is the law developed by the judges through the courts. It inevitably develops in a very haphazard way, because the courts can only deal with matters that are brought before them. So, if something is not the subject of adjudication by the courts, then the courts are not in a position to develop law to deal with it. And for that reason, English law has developed in a very uneven way. In some respects, there are areas which are highly developed. Those who had money, those who could bring cases to the courts, tended then to be leading the way toward a development in an area of law which wasn't going to be paralleled in circumstances where matters affecting those without money was involved. So the common law essentially developed through the decisions of the courts, and we'll look further at that in a future lecture. If we turn now to the system of courts that operate in this country, they are also arranged in a hierarchical fashion. They also are separated into courts which deal with civil matters and courts which deal with criminal matters. If we look first at the courts which deal with civil matters, at the top, for the time being, we have the House of Lords. This is going to be replaced in 2009 by a new Supreme Court, which will sit at the apex of the court system. The House of Lords deals with cases which involve an important point of law. And so very few cases are heard by the House of Lords. A lot of these tend to be cases that have wide implications. So, for example, cases to do with tax tend to find their way to the House of Lords because there's such a widespread implication involved in any ruling relating to whether a person is or is not liable to tax. But the House of Lords hears lots of other cases of importance, and particularly following the coming into force of the Human Rights Act in October 2000, the House of Lords has been at the forefront of cases involving human rights. Below the House of Lords sits the Court of Appeal Civil Division. This is usually staffed by benches of 3 judges, and they hear appeals from the High Court and from the County Court in civil matters. They are probably the area where the law is most developed, because appeal courts have an important function in drawing together disparate decisions of courts lower down the chain and trying to mould them into a principle which then becomes applicable in future cases. The Court of Appeal deals with a much larger number of cases than the House of Lords. Below the Court of Appeal, we have the High Court, which is split into 3 divisions. These are the Chancery Division, which deals with matters to do with trusts, wills, companies, that sort of thing. The Family Division, whose name is self-explanatory, deals with matters to do with family and children. And the Queen's Bench Division, which has a jurisdiction dealing with commercial matters. Below the High Court is the County Court. These are the local courts which deal with smaller civil matters involving, for example, debts, consumer issues, that sort of thing. And finally, at the bottom of the court system, we have the Magistrates Court. The magistrates deal with certain civil matters, civil debts. They deal with family matters. So we have a system which is hierarchical and which allocates different types of jurisdiction to different courts. If we turn to the criminal jurisdiction, again at the top we have the House of Lords. It deals with very few criminal cases, but those it does deal with, it provides rulings which are important for the development of the criminal law. Below the House of Lords, we have the Court of Appeal Criminal Division. Now, the Criminal Division, again, like its counterpart in the civil law, is essentially the area which does the bulk of the work in defining the major principles of criminal liability and in developing the idea of a person obtaining a fair trial. The main area for dealing with trials of serious offences is the Crown Court. Crown Court deals with offences which are indictable or which are either way offences tried on indictment. These are the more serious offences, and they're heard by a judge and jury. The idea here is that lay people are more involved in the determination of whether a person has committed a criminal offence or not. And at the bottom we have the Magistrates Court. Magistrates courts deal with the vast majority of criminal cases. Most cases start and end in the Magistrates Court. They deal particularly with the large number of summary or more minor offences. However, the magistrates' jurisdiction is slightly reducing as there is an increase in spot fines, so that cases don't need to come to the magistrates for determination. The person is simply fined on the spot. And it will be interesting to see in the future how that affects the magistrates' jurisdiction.